Before we show the hearing from today, where it was talked about briefly, let's talk about that consolidation issue and what the options are and what might happen. Give me your best take.
Well, on the consolidation issue, with regard to this, since there has been some type of, now I won't say agreement, but mention in court that the O'Keefe lawsuit parties are not adverse to a consolidation, I think they're going to let the courts call them. Quite frankly, I know we heard that Plymouth may be the best place for it. It's the first place it was the first suit that was, according to Michael Del Signor, our Massachusetts attorney, filed, and therefore they may get the thumbs up. But I think this may go to wherever the court system thinks that it's best handled, and that could be Bristol, because that's also where Karen Reed is. And quite frankly, if you're going to say who has the most witnesses that are going to have to come in, it's going to be her. However, the Taunton courthouse is very small. So, all that is going to feel into this, fold into this, go into this. It's going to be a meat grinder.
Yeah. So I was asking you, Judge Linda Kenny Bodden, how you come down on this based on all of those
I move
factors.
it all to Boston. I move it all to Boston.
You move it to Boston?
I move it all to Suffolk County, okay? And
Wow.
I say, because we have so many parties here, because we need people to be able to get to the courthouse, we need to have so many witnesses, because we have the Massachusetts State Police involved. Me, as the center judge, as the top judge of the state of Massachusetts, whoever is assigning this, is moving this to Suffolk County.
Okay, that was off the board. You went off the board for that one.
I certainly did.
I voted today for Plymouth, just having been there and seeing the facility. They can handle it. It's great. It's not like a Dedham or a Bristol, which is quaint and antiquated. This can handle bodies and tech and all of the things they're going to need for this case in 2028 when it finally comes to trial. Anyway, so let's listen now to some of the hearing. It was a whole 15 minutes that was actually streamed on the Zoom. I don't know when it really started. It was supposed to be at 2. At 2:45, it comes up, boop, pops up, and it seems like it's mid-discussion. But, Missy, if you have that handy, let's jump into that. It was only about 15 minutes long.
When it's time for us to be able to inquire.
Mark Taylor is
Your Honor, let me just quickly respond to that. First of all, I'm a little concerned.
It's already in progress.
Listening to my brother, counsel, read from what looks like a scripted message that doesn't seem to deal with any issues, because there's been no motion to compel that's been served on us relating to those answers. There's been nothing filed with the court. Instead, my brother, counsel, is reading from a script for what I'm guessing is some other purpose. And what we'd like to do is we'd like to just...
Attorney Waters, excuse me for interrupting, but maybe we'll take this as a 9C conference. You heard what he's looking for. What do you say to it?
Your Honor, actually, I don't know what he's talking about, to be candid. I think that Karen's statements have been consistent, and they're certainly consistent with the lawsuit that's been filed in Bristol County. So my brother counsel is going to have to be more specific about what he thinks is inconsistent. I don't think it is at all. And that's usually why motion practice is a good idea.
Attorney Diller, I guess we'll consider the 9C conference conducted and file whatever motion you want to file.
Thank you, Your Honor.
Okay, hold it just for a second there, Missy, so we can chat about what just happened. This has to do with some outstanding discovery that hasn't been supplied, and they're going to be bringing a motion to compel. They're going to coordinate that with the next status conference, which I believe the date they ended up on was December 19. So that's what that's about. We're in the early parts of discovery in the case in which both parties have, I shouldn't say both parties, some of all the parties have complied and appeared, and that's, of course, Plymouth. We can't even get into Bristol. That's not even started. We heard, though, today that a couple of the folks were accepting service. Remember, the defendants in that are the Alberts, McCabe's, and Higgins. And they were vague about who was accepting service, the attorneys accepting service. The way this works, for folks who may not be familiar, even as a party to a lawsuit, until you're in, you have to be served, right? And if not physically served, where they touch you and run away, that's the image they always create, that you're touched with the papers and the server runs away. It's not quite that crude, but you have to be officially served by the sheriff or a professional server, unless you agree, and then through your attorney, you accept the lawsuit on their behalf. It's cleaner, it's more civilized. And I think that's probably what's going to happen for all of these defendants. But who knows? We're talking about the McCabe's and the Alberts and Higgins. Who knows what they're going to do? Higgins may take his and throw it in a dumpster. I don't know. So that's where we are. Okay, let's roll on here.
What's the status of the discovery with CNC Hospitality and GNS? Attorney Diller, I guess we'll consider the 9C conference conducted and file whatever. Attorney Diller, did you receive responses?
I did. Well, both parties had reached out to us over the history of this case. We may have propounded that discovery even before, while the criminal matter was going on, maybe around the time of the stay. But they then reached out to us at separate occasions and were very upfront about the fact that they're compiling discovery and needed more time. We allowed that additional time. Yesterday, we received some discovery, which I think I indicated to you, I have not reviewed yet, but we have received discovery from both bars. One bar, and forgive me for not recognizing which one is which, one bar may have sent me some preliminary discovery a couple weeks ago and then supplemented it yesterday. The other bar sent me a batch of discovery yesterday, none of which have I had an opportunity at this stage to review. One bar sent me some preliminary discovery a couple weeks ago and then supplemented it yesterday.
Anyone else want to offer anything on behalf of any of the parties?
Okay, and hold on a second here, Missy, while we listen to the deafening silence. What's the name of the new judge? I forgot. I know that O'Shea is retiring, so he's gone. I can't remember the name of the new guy. Do you remember? Anybody remember? Send that along. I thought it started with a G, but I'm not sure. Anyway, he's the guy that the video disappears and he's in the little teeny box on the top. Let's talk about this discovery. I'm going to give you a quiz because I happen to hear some of this here today. There's been some discovery by one bar to the plaintiffs, the O'Keefe family, in the first case, right? Any guess on the number of documents? Just take a wild guess.
On the number of documents produced?
A number of documents produced by one of the bars to the O'Keefe plaintiffs.
One.
So far, and we're going to hear it again, so if I'm off on my memory, I apologize. I believe it was 1,000 so far. I may be wrong.
I've got the one part right.
You got the one. That may even be a little light, but here's the number I remember. There is supposed to be, not yet produced, but identified 1 million documents. 1
million documents. You know what that reminds me of? That reminds me of
Ford Motor case.
The Ford Motor or old IBM cases. They'd say, here, this is what you asked for. So here's your rooms full of documents and boxes. And you go, and of course, in there is a smoking gun, but you can't find it because it'll take you a while. So I think that's going to, there's going to be a lot of whittling down on that. That obfuscation, I'm going to call it.
We'll hear again. Maybe my hearing was bad, but for those who don't remember the Pinto case, Ford Motor Company Pinto case, they filled a room with those banker boxes, and inside those were in response to requests for documentation. It's called, depending on the state, either a document request. That's what we call it in California. What is it in New York, New Jersey?
No, it's a request for documents.
Okay, so they gave them documents already. Inside one of those boxes that I'm sure a bunch of law clerks sweated hours and hours pawing through was the smoking gun letter that said Ford Motor Company knew that putting the gas tank in the Pinto right behind the bumper, I guess in front of the bumper and behind the passenger compartment, might be a problem. And you'll remember the cases that led to the lawsuit. People were getting rear-ended. Boom, the gas tank explodes, fills the car with gasoline, and people died. The smoking gun memo said, we knew about that, but we factored in the cost of paying people off with redesigning and replacing the gas tank. Unbelievable.
So that's what we're talking about, and they've done a lot of other cases. Now, some of those may be responsive, but usually what you get is that your document request is overly broad. We can't give you anything unless you narrow it down. The other way of handling it is to do this. Here's 1 million documents. Find what you you can't accuse us of not complying.
Yeah. Okay. Sorry for the interruption. Let's move back into the horribly framed conference room shot so nobody is identifiable.
Attorney Hassett on here for Waterfall. Anyone else want to offer anything on behalf of any of the parties?
Yes, Your Honor. Attorney Hassett for Waterfall.
Afternoon. Do you want to offer anything?
Your Honor, I would just say that with respect to the discovery, we have in fact responded to the plaintiff's discovery after an extension was granted. We did the interrogatory answers. Those have been complete. The document responses were, as Attorney Diller indicated, in 2 stages. We completed that as well. We have yet to propound discovery ourselves at this point. Obviously, there's a history in this case that occurred on through 2 criminal trials. It was our approach to see what documents were produced from the various keeper depositions and the other document requests among the parties. And then from there, after looking through the documents, make a decision as to what more pointed interrogatory answers we would propound. And as was indicated earlier, we've got a fairly lengthy discovery on a average tracking order, which permits discovery through next August. So in terms of our own discovery and our plan on propounding it, we were hopeful that we'd be able to wade through some of the voluminous documents first.
Who's here for McCarthy's? Is it Attorney Smith?
Can I just stop a second? I'm actually laughing because one of the things that we all know about there, like when we're doing TV and we're trying to frame a shot, we're not perfect. But sometimes when you are on a Zoom case with the judge, now let me do this, and I'm going to embarrass myself. I'm going to lean way in, okay? That's like something you should not do because I'm probably scaring you all.
How's this shot? How's that? Is that good? You like that shot? Yeah. I mean, it's just common sense sometimes out the window, and we're seeing it here. Let's put 4 people at a conference room table.
I'm sorry. Can I just say the reason why I say that is because eventually somebody, if it doesn't settle, has to try this case. And you have to be jury friendly and jury likable. Okay. And I just would like to point that out. If I were somebody advising somebody doing the Zooms on these right now.
Yeah, there needs to be a class, I think, for attorneys in Zoom principles, because it doesn't take a rocket science. It just takes a little common sense. So anyway, moving on.
Donovan, is Attorney Smith?
She is, yeah. Attorney Smith.
At least nobody's shown up with a cat filter on their face.
Your Honor.
Good afternoon.
Good afternoon, Your Honor. Attorney Tamara Smith for CF McCarthy's. Thank you for the opportunity to speak. Yes, as has been stated, we did produce several hundred pages of documents yesterday, have responded fully to the plaintiff's answers, to the plaintiff's interrogatory requests. And like counsel for Waterfall, there's, as indicated in this call today, over 1 million or about 1 million pages and documents that are forthcoming. So the thought here would be to see what is there so that there's not duplication of effort and additional requests put out that are already answered by what is already forthcoming.
All right, let me just stop again.
Yeah.
All right.
Yeah.
And this is not on this, but let me put it this way. I will guarantee these are insurance carrier lawyers, right? Okay. All right. Let me put it this way as a plaintiff's lawyer. And I've done some defense. I've defended some big companies.
I'll then speak as a defense attorney. You go ahead.
Okay. Insurance carrier lawyers, love this because they bill by the hour. They may have a budget,
What do you say?
They may have a budget, right? Because they have to submit a budget, okay? But they love to be able to bill by the hour and bill the paralegals to put together documents. I'm not saying that there was an abuse in this case. I'm just talking about my general feeling, having practiced law for a period of time and having been in cases that have insurance defense. Plaintiffs' counsel a lot of times do not bill by the hour. They're on a contingency. So they want to try to move things along and not spend wasted time. All right. So I would just point that out, and you can take it for what it's worth.
So as an insurance defense attorney for a number of years, I can't really dispute that. I will put a fine point on it. We billed, if I was in the shower thinking about the case for 5-6 minutes, I'm billing that. That's 1/10 of an hour. We billed in 1/10 of an hour.